All right, welcome to today's video. Thanks for joining us again. As I said in the opener, we're going to be discussing two key concepts that you have to know for your real estate licensing exam. And quite frankly, it is something that is pretty something you need to know in the real estate profession itself. And that is public and private land use controls. Now, understand from a previous video that I did on what we call the bundle of rights. That video outlined all the things that you as a private owner of real property, the interest in the things that you can do with that property. You can lease it, you can lease it, you can mortgage it, you could rent the property out, you have subsurface rights and air rights and surface, all that stuff. All that stuff we discussed as the bundle of rights, all the things that you're legally allowed to do because of the interest you have in that property. Well, as the history of the company or the country progressed from true absolute ownership in 1776 to where we are today, there is mechanisms that were put into place where it allowed individual owners to place restrictions on the property for future owners. And there was a mechanism put into place for government agencies to impose restrictions or use controls on the property as well for the benefit of the general public. And we're going to discuss both of these concepts here in this video. All right, so the first concept I want to talk about is what's called private land use controls. This is where private owners of real property, they place what's called a deed restriction. And that is a key real estate term that you must know for your real estate licensing exam. So that private owner places a deed restriction in that deed. And what it does is the new owner is buying that property, or they hold title to that property, what's called subject to, quote unquote, subject to compliance with that deed restriction. Now, deed restrictions must comply with zoning laws, and they can't be contrary to a law or a fair housing law or something like that. So let me kind of illustrate what I'm talking about here. So many years ago, I owned a piece of property in Iowa. Now, Iowa is an abstract state, and we did discuss abstracts in a previous video. And I was reading through the abstract, because remember, an abstract is basically a history book of the ownership of that property from the time it was first land patented all the way to date. And somewhere around 1920, there was an owner of this piece of property, and she was the mom, and the mom transferred title to the son with a deed restriction. And the deed restriction said that if the son ever married a particular girl from a specific family, and she named the family, the actual name of the family in that deed restriction, then the property, the title to the property would automatically revert to the Catholic Church. Another thing that was very common prior to the fair housing laws is a deed. Like, I could put a deed restriction in the property that said this property can never be owned by African Americans. And if it was, then it would, title would revert to whoever. That was legal up until the point we started putting the civil rights laws and the fair housing laws into the books. And now those type of things are illegal. In fact, I just did not too long ago fair housing training for a condominium regime. And they had an old master deed, and we discussed that that's a key real estate term for a different video. But in the master deed, it said no children can live in the condominium regime. Well, obviously that now violates fair housing law as of 1988, where family status is a protected class, but they never updated the master deed. And so that is an example of deed restrictions that were put into place that are illegal. But a deed restriction in this context is where private owners are placing restrictions for future owners, not only the immediate future owner, but subsequent owners. Now, the most common type of private land use control, is what's called a covenant. Now, covenants are very prominent in the real estate sales community. Just about every new subdivision has some type of covenant put into place. Now, covenants are really known as covenants, conditions, and restrictions, or sometimes referred to as a CC&R. They are a deed restriction that's been placed into that deed by the developer, okay? That developer is a private owner that's passing title onto that property to you or me, but you have to comply with the covenants. Now, covenants restrict the property owner's ability to use the property. And here are some very common, I guess, some restrictions that we see in covenants. And I have them on your screen here. Fencing, the type of fencing. Can you have a fence? And if you want a fence, do you have to go to the homeowners association to get approval? The height of the fence, the style of the home. There are some subdivisions that have covenants that only allow certain styles, maybe ranches and 2 stories only. They don't allow split entries. Minimum square footage requirements. So the homes built in that subdivision have to have a certain minimum square footage requirement. The color of the home is another popular one. So you're limited on the colors that you may paint your home. Parking restrictions. You can't park RVs and boats for no more than 72 hours is a common one. Exterior buildings. Can you have the shed in the back to put the lawnmower in? Flags. It's not listed on there, but flags is one that we hear all about in the news. And then rentals. Can this property be a rental property or not? Understand this is just a few of the multitude of different restrictions that can be placed into covenants. And it's the homeowners association that typically is tasked with enforcing the covenants and issuing citations and violations and those type of deals. Those are private land use control restrictions. The next one I want to talk about is public land use controls. Now, with public land use controls, this is where government agencies, your city, your county, maybe the state, or even the federal government, they are imposing restrictions on your property that you own. Most common ones are things like zoning laws. So if your property is zoned residential, you can't have a garage there unless you go through the proper variance process. Building codes is another one. Environmental laws. And then the last one is wildlife protection. And most of the time, this comes from the federal bank of statutes. But for example, I actually knew a couple that purchased 40 acres of timberland in Oregon. And they purchased it. They had a mortgage on it, everything. And then it was discovered that there was spotted owls on the property, and at that time, the spotted owl was on the endangered species list. So they had purchased the property, and the property was valued based on the wood, the timber that was on there. Yet the owners, once that spotted owl was discovered and the federal government said you cannot touch the property, they could do no logging. And that is placing land use controls on that property. Now, understand under public land use controls, as we discussed in a different video under police powers, because all of these things on your screen are examples of police powers. There is no compensation, and title does not pass to the government. So the government just places the controls into place. They're not going to compensate you for that, nor is title passed to the government under these particular types of land use controls. All right, so if you're going to continue studying, I highly recommend that you check out this video right here on zoning. Very important, because zoning and these two doctrines go hand in foot. And if you have not subscribed to the channel, please do so. Click that little circle to my left. I would appreciate it. Comments, questions down below. I'll see you all in the next video.